Please be seated. The court is now back in session. The chamber will now proceed with the two issues. That is in relation to the available resources for the two defense teams. The two defense teams notified the chamber yesterday by an email that they wish to make an oral submissions regarding the availability of the resources that may have a short-term and long-term impact on their on the performance of their duties. After they received a request from the Administrative Office of the ECCC. First, I'd like to hand the floor to the defense team for Noon Chia to make an oral submission on this issue concerning their team. You have the floor.
Yes, Mr. President, thank you for this opportunity to speak about this issue. Indeed, this week we received quite alarming news that the Office of the Administration is considering substantially cutting the budget of both defense teams. Apparently, I'm not quite sure about this, but there has been pressure from donors that also the defense should accept cuts in their budgets. Apparently, because of funding issues, all sections of the ECCC are dealing with this, and it seems that the donors believe that we have sort of to face the same consequences. Our understanding is the following, that as per the end of March, hence 24 days before the deadline of our closing brief, effectively two team members have to leave, or their contracts will not be renewed. These are as I understand, the team members who have been added in respect of the many disclosures that we had from cases 3 and 4. This is, of course, a substantial departure from earlier things that were said to us by the Defense Support Section. As the Chamber is well aware, the disclosures from cases 3 and 4 keep continuing. As a matter of fact, yesterday, new disclosures were put on the case file, and yesterday the co-prosecutors proposed to disclose another batch of disclosures to us. If indeed two very valuable team members have to go because of these cuts 24 days before the closing briefs are due, that is highly problematic in terms of preparation for our closing brief. Alternatively, mention has been made that if these plans will not materialize, then the budget that was attributed in relation to the case 3 and 4 disclosures will be substantially cut immediately after 24th of April, the day of the closing brief. Again, that is also highly problematic if that would be an alternative scenario, because between the 24th of April and the closing submissions, of course, we have to react substantially and materially to the closing brief of the co-prosecutors. It is only then that we will be aware of which evidence from cases 3 and 4 the co-prosecutors find particularly relevant and important. If this intention of the Office of the Administration materializes, we are in deep trouble in terms of preparing our defense, both for the closing brief and for the closing submissions. If that is indeed the case, then we will be forced to request to extend deadlines and ask, and that will of course delay the trial substantially, something I believe and I'm certain of nobody in this courtroom wants. Our request, Mr. President, would be that the Chamber gets in contact with the Office of the Administration as soon as possible in support of our position, maybe in the same way as the Chamber has expressed support in relation to the issue of the translation of court transcripts, an issue that we discussed during the last trial management meeting. Although it's not a decision yet, it is apparently an intention to decide as such. We felt it nevertheless important to raise this issue as soon as possible so that the Chamber is hopefully still in a position to change the course of the Office of Administration.
Sorry, can I just ask, so we have it on record, you have informed the Office of Administration of all these facts? They are aware of it?
Yes.
Counsel for Case and Pond, you had the floor.
Merci, Monsieur.
Thank you, Mr. President. A few additional observations. Perhaps to begin, what we need to clarify, at least on behalf of the Kyosampan team, is that we're currently discussing with the administration, and perhaps what we're asking of the Chamber is a pedagogical aid, let me put it that way. The problem that often occurs in this type of thing is that everyone has the impression that the only work that's being done by defense teams or others is when we're actually in the trial chamber, but perhaps we need to remind certain lawyers who haven't been in the courtroom for a while, or for those who are not lawyers, that it's just the tip of the iceberg. In order to get to the closing briefs and closing arguments, there's an enormous amount of work that people don't see, but that is just as fundamental, essential, and important. So, very clearly, this pedagogical support that we are asking the Chamber to extend to the Office of Administration is to express themselves specifically on this issue concerning the closing brief and the closing arguments. It's that if you've agreed to have more time and more words in case file 201 for the closing briefs and closing arguments, that you are aware that on behalf of the parties, the mass of documents and legal elements and legal discussions to be dealt with is much less than in the case 2-1. And once again, we hope that the information that we're going to be reiterating will be heard and accepted. When we envisage cutting 2 members of our teams by the end of March, and particularly people who were added because, well, among other things, because it's never quite that simple, but specifically related to the evidence coming from case files 3 and 4, I would like to recall, and perhaps this is important, that we are awaiting a certain number of audio files that will need to be used by the people in charge of this issue. Therefore, it's not at the time that we submit the closing briefs that the excess of work will stop, because there are 800 pages of the closing briefs of the co-prosecutors that we will need to go through at that point. And the masses of pieces of evidence and discussions on legal issues we will have to have during this period. You apparently understand this, but obviously the Office of the Administration does not understand this. And so once again, we hope that discussions will be fruitful with the Office of Administration, but what we're asking of you is to remind and explain to the Office of Administration that it's not at the time when we'll have this mass of work and documents to deal with that we would have our resources cut off to be able to carry out our work. We do understand that it's a complicated situation, but to cut our resources at this crucial time and to reduce our teams at this crucial time is simply impossible to understand, and therefore we are asking the Chamber to extend this pedagogical effort, as I said, towards the Office of Administration on our behalf.
To be a bit more precise, if I understood the Nunchia team correctly, what they are asking, let's say as a minimum, you can obviously always ask for more, is the extension of the contract for 2 team members for 2 months, which is the end of May, because closing speeches are at the beginning of May.
End of June, because the closing submissions are in June.
That's why I said end of May. Closing speeches are on the 5th of June.
Yeah, so what we would ask is contracts to be extended to 30 June or 21 June, the day after the very last closing submissions.
Okay.
So, yeah.
And it amounts for your team to what?
C'est la même chose que nous ayons la...
See, it's the same thing that we have.
Je sais pas comment...
I don't know how to tell you, just the current configuration of the team should be retained until the last day of the hearings on closing arguments. We should maintain the same team until then.
And the line now to hand the floor to the co-prosecutors to make an observation or to respond to this issue, because this matter is clearly related to the co-prosecutors, since you the teams that disclose information from cases 3 and 4, and that have an impact on the resources from now until end of June.
Thank you, Mr. President. We did not plan to make any submissions, but I'm happy to provide any information that would help the Chamber. I gather from your last remark that you're asking us for some prognosis of disclosures. What I can say is that I think disclosures have slowed down because we caught up with most of the backlog. I haven't been briefed this week about exactly where we are, but as you know, may know that yesterday another investigation was preliminarily closed. So, OCIJ continues to investigate. I'm not sure exactly how many more statements they will produce. We are obligated to review all of those and will continue to do so. However, it appears that 3 of the 4 cases are at least preliminarily closed by OCIJ. And we will continue to review all new material produced to see if it fits the requirements for disclosure.
And lastly, I hand the floor to the lead co-lawyers for civil parties.
No particular observations on the request of the defense, Mr. President, which seems to us to be legitimate. We ourselves do not have this problem on the international side. We are all consultants. We all have contracts which are renewed monthly. But we have not been informed that certain of those contracts would be eliminated in the month of March simply because we haven't had any recruitment connected to the disclosure of evidence from cases 3 and 4. We have a different configuration. So.
President, the Chamber would like to thank parties for raising their concerns and responses to the issues, and the Chamber will take all that matter into consideration and to consult with the Office of Administration in order to deal with this issue. And the Chamber will proceed to the final step of the proceedings in case 002. And the Chamber will now address the final procedural steps to be taken in case 002/02. The Chamber has set for 274 hearing days in case 002/02 and had the testimony of 114 witnesses, 63 civil parties, and 8 experts. A few decisions or the reasons to follow for certain decisions already made remains to be issued. This will be finalized as soon as possible by the Chamber. In addition, there remains pending before the Supreme Court Chamber an immediate appeal filed by the civil party lead co-lawyers seeking to clarify that the trial chamber, is seized of factual allegations of rape outside the context of forced marriages. The lead co-lawyers, however, have indicated that they will not seek to hear additional witnesses if their appeal is granted. At this time, the Chamber does not envisage hearing any further witnesses. Therefore, today is the final day of evidentiary hearings in case 002/02. The Chamber, however, notes that it may reopen the proceedings to hear the testimony of 2 TCW 946 no later than 31st January 2017, if it can arrange the video link testimony of the witness through the cooperation of the German authorities. The Chamber will notify the parties on the development in this matter. For the next step in these proceedings, the Chamber has set deadlines for closing briefs, which are to be submitted on 24 April 2017 in a single ECCC language. No written responses will be accepted. The co-prosecutor's closing brief shall be no more than 800 pages, whereas the defense teams shall have 550 pages each. The lead co-lawyers shall have 550 pages for submissions on all issues, including reparations. The final claim for reparations is due on 22 May 2017. Closing statements will be held starting 5th June 2017. The lead co-lawyers have been allocated 1 day, the co-prosecutors 3 days, and each defense team 2 days. 1 day has been allocated for rebuttal and 4 hours for the final statements of the accused, should they choose to exercise that right. Should any party not require the full time allocated to them for closing statements, they are requested to inform the Chamber and other parties as soon as possible to facilitate scheduling. The Chamber thanks the parties for their assistance and cooperation throughout the proceedings in this case. The Chamber would also like to thank all of the court staff, including interpreters, transcribers, court officers, audiovisual technicians, medical personnel, and members of the detention unit for their outstanding respective roles in facilitating these proceedings. The Chamber will adjourn now, and it will resume on the 5th June 2017, commencing from 9 o'clock in the morning. Security personnel, you are instructed to take the two accused, Noon Chi and Kee Sampon, back to the detention facility. The court is now adjourned.